Put the facts into a clearer chronological order, and then let later claims incorporate those facts by reference. I am using a general allegations first, claims second structure, because that is the best balance between chronology and doctrine for your case. This also better fits the Rule 8 concerns in the recommendation and the original form's claim language. Attach Section D, Statement of Claim, continued, general allegations. 1. Plaintiff Rex A. Fredrickson is a resident of Wellington, Colorado. 2. Beginning in or about 2020 and continuing thereafter, defendant Chad Gray, acting under color of state law and using the authority and apparent authority of his public position, interfered with plaintiff's housing arrangements in Larimer County, Colorado. In College Avenue, Fort Collins, Colorado, Gray threatened consequences associated with his official authority, including statements that a building would be bulldozed if plaintiff did not leave. 3. As a result of those threats, plaintiff was required to leave that residence abruptly. 4. After plaintiff relocated to Willocks Lane, Gray again interfered with plaintiff's housing by threatening the landlord with fines exceeding $10,000 if the landlord did not proceed against plaintiff. File site, turn 56 file 1 lane period. Gray also threatened to obtain a warrant to have plaintiff's bus removed. 5. After plaintiff later moved to 12908 Palomino Place, Wellington, Colorado, Gray again attempted to interfere with plaintiff's housing by sending threatening emails to plaintiff's landlord. 6. Plaintiff alleges rived plaintiff of housing stability without notice, hearing, or ordinary process and formed the beginning of a broader pattern of retaliation and destabilization. 7. After plaintiff sought legal relief concerning his displacement and related matters, defendants David Archbell and Robert Thayer began a repeated course of confrontation, intimidation, surveillance, recording, and public targeting directed at plaintiff. 8. In one incident, Archbell and Thayer co-shopping center parking lot while visibly armed. 9. Plaintiff alleges they approached plaintiff in a hostile manner, engaged him verbally, recorded the encounter, and later published the recording online with commentary portraying plaintiff as dangerous or unstable. 10. Shortly afterward, Archbell again confronted plaintiff while visibly armed inside a Super's grocery store, followed plaintiff through the store, recorded plaintiff at close range, and attempted to provoke a reaction. 11. Plaintiff alleges that this confrontation also was later used in public targeting. 12. Plaintiff further alleges that another confrontation occurred at or near the Loaf and Jug gas station, adding to the same pattern of intimidation, recording, and hostile escalation. 13. Plaintiff alleges that from 2022 through 2025, Archbell and Thayer continued to monitor plaintiff, appear at places where plaintiff was present, follow plaintiff during routine activities, record plaintiff, publish material about plaintiff online, and extend that conduct to plaintiff's residence and surrounding neighborhood. 14. Plaintiff alleges that this course of conduct included drive-by filming and publications, mailboxes, surroundings, and nearby identifying features. 15. Plaintiff alleges that the publication of plaintiff's residence and personal circumstances increased the danger to plaintiff, caused fear, and undermined plaintiff's housing stability. 16. Plaintiff alleges that Archbell and Thayer's actions were not isolated events, but a continuing course of conduct directed at plaintiff after plaintiff attempted to use legal process and obtain protection. 17. Plaintiff further alleges that Robert Thayer publicly claimed that his contracts had been extended and publicly referenced David Arod by name in a manner suggesting that Thayer had backing, benefit, or tolerated status connected to Larimer County. File site, turn 56 file 11, turn 56 file 14, turn 56 file 818. Plaintiff alleges that these statements mattered because, or institutionally backed. 19. Plaintiff alleges that he brought those facts to the attention of county officials, including David Arod, and sought intervention, neutral review, or protective action. File site turn 56 turn 56 file 1720. Plaintiff alleges that Arod responded to some of these communications or information concerning Thayer and later centralized or controlled communications in a manner plaintiff contends functioned as gatekeeping rather than neutral review. File site turn 56 file 410, Pine turn 56 file 7 time. 21. Plaintiff alleges that despite repeated notice to county and city actors, surveillance, intimidation, online targeting, and danger to housing stability, meaningful intervention did not occur. 22. Plaintiff alleges that he also sought court protection through protection order proceedings against Robert Thayer. 23. Plaintiff alleges that a prior order of protection had at one point been granted before later being overturned, and that the related protection order history forms part of the broader context for the events of October 20th, 2025. 24. On October 20th, 2025, plaintiff appeared for a scheduled rehearing or reconsideration setting in Larimer County concerning temporary restraining order, protection order proceedings involving Robert Thayer. 25. Plaintiff alleges that Thayer had not yet been served at that point and that service was necessary for the S to proceed. 26. After the hearing, plaintiff observed Thayer in the courthouse parking lot. 27. Plaintiff alleges that Thayer remained there recording, signaling, or otherwise behaving in a manner that led plaintiff to believe Thayer was waiting in advance for plaintiff to leave the courthouse. 28. Plaintiff then attempted to complete lawful service of the reissued papers in a public and neutral setting with a third-party AABUIF, alleges that Thayer drove to the Fort Collins Police Department and plaintiff followed there because plaintiff believed a police facility was the safest and most neutral location to complete lawful service and to report the courthouse confrontation. 29. Plaintiff alleges that at the police department, he explained his purpose, sought police standby or assistance for lawful service, and attempted to complete service of the court papers. 30. Plaintiff alleges that police refused standby, refused to permit plaintiff's third-party server to complete service there, and did not allow service to be completed at the station. 31. Plaintiff later completed service by email, which plaintiff alleges was ultimately treated as valid. 32. Days later, Fort Collins Police issued plaintiff citation arising from the same October 20th, 2025 events. Plaintiff alleges that this enforcement action a legitimate non-retaliatory basis and was tied to plaintiff's attempt to use lawful court process. 33. Plaintiff alleges that over an extended period he reported Thayer's and Archbell's confrontations, intimidation, surveillance, and harassment-type conduct, providing dates, locations, and supporting publicly posted recordings created by Thayer and Archbell. 34. Plaintiff alleges that despite repeated requests for enforcement and protection, officers repeatedly declined meaningful investigation or protective action regarding Thayer's and Archbell's conduct. 35. Plaintiff all-dare pattern included housing destabilization, public targeting, administrative gatekeeping, retaliatory citation, and institutional non-response after notice. 36. Plaintiff alleges that as a result of the lie, he suffered fear, emotional distress, loss of housing stability, out-of-pocket expense, reputational injury, interference with his use of court processes, and continuing danger. Claim 142U 1983, 14th Amendment due process, deprivation of housing, property interest, without due process against Chad Gray. 40. Plaintiff incorporates paragraphs 1 through 8 as if fully set forth herein. 41. Defendant Chad Gray, acting under color of state law, used threats associated with his official authority to pressure landlords and housing providers into removing plaintiff from housing without notice, hearing, or ordinary process. File site turn 56, file 1, turn 56, file 11, 42. Through the acts described in paragraphs 2 through 8, Gray deprived plaintiff of housing-related and property interests without due process of law in violation of the 14th Amendment and actionable under 42 U.S.C. 1983. Give Part 2 of 4, which will continue with the next claims using this structure. Claim 242 U.S.C. in 1983, joint action theory, 14th Amendment and First Amendment, repeated harassment, intimidation, surveillance, and public targeting by David Archbell and Robert Thayer. 43. Plaintiff incorporates paragraphs 9 through 18 and 36 through 39 as if fully set forth herein. 44. Defendants David Archbell and Robert Thayer repeatedly confronted plaintiff in public, followed plaintiff, recorded plaintiff, published recordings or commentary about plaintiff online, and extended that conduct to plaintiff's residence and surrounding neighborhood. 45. Plaintiff alleges that this conduct included armed or weapon-related intimidation, hostile confrontations in public places, drive-by filming of plaintiff's residence, and public targeting intended to expose plaintiff and increase fear and instability. 46. Plaintiff alleges that these acts were directed at plaintiff after plaintiff attempted to seek legal relief and protection. 47. Plaintiff alleges that the conduct of Archbell and Thayer caused fear, emotional distress, reputational injury, interference with normal movement and daily life, and increased danger to plaintiff's housing stability and personal safety. 48. To the extent Archbell and Thayer acted jointly with state actors or in concert with public officials, plaintiff alleges that the acts described above violated plaintiff's rights under the First and 14th Amendments, actionable under 42 U.S.C. 1983. 42 U.S.C. Pro. 1983, 14th Equal Protection, selective and unequal treatment by law enforcement and public officials. 49. Plaintiff incorporates paragraphs 19 through 23 and 31 through 39 as if fully set forth herein. 50. Plaintiff alleges that when he reported intimidation, surveillance, public targeting, and danger, his complaints were not treated in the manner that a similarly situated reporting party would ordinarily expect. 51. Plaintiff alleges that despite notice, public officials minimized, disregarded, or failed to meaningfully investigate plaintiff's complaints while allowing the targeting conduct to continue. 52. Plaintiff further alleges that when plaintiff attempted to complete lawful service of court papers and used judicial process to seek protection, the response was not neutral and instead culminated in retaliatory or unequal treatment. 53. Plaintiff alleges that this unequal treatment was influenced by stigma, hostility, or assumptions associated with plaintiff and by public narratives promoted by those targeting him. 54. Plaintiff alleges that the conduct described above denied plaintiff equal protection of the laws in violation of the 14th Amendment, actionable under 42 U.S.C. Paragraph 1983. Claim 42 U.S.C. 1983, First Amendment retaliation, access to courts, retaliatory citation and interference with lawful service on October 20, 2025. 55. Plaintiff incorporates paragraphs 24 through 35 and 39 as if fully set forth herein. 56. On October 20, 2025, plaintiff attempted to use lawful court process by pursuing protection order proceedings and then attempting lawful service of reissued papers in a public and neutral setting. 57. Plaintiff alleges that after he sought police assistance or standby to complete lawful service, police refused to facilitate or allow that service at the station. Plaintiff alleges that days later, he was charged with criminal harassment based on the same events. 59. Plaintiff alleges that the citation was retaliatory because his conduct was tied to seeking judicial relief, attempting lawful service, and reporting the courthouse confrontation. 60. Plaintiff alleges that this retaliatory enforcement burdened and chilled his exercise of rights secured by the First Amendment, including petitioning the courts and seeking protection through lawful process. 61. Plaintiff alleges that the conduct described above violated plaintiff's rights under the First and 14th Amendments, actionable under 42 U.S.C. 1983. Claim 5, 42 U.S. Pride 1983, 14th Amendment/liberty, safety and security interests, publication of residence, public exposure, and increased danger. 62. Plaintiff incorporates paragraphs 15 through 18 and 36 through 39 as if fully set forth herein. 63. Plaintiff alleges that Archbell and Thayer recorded, live-streamed, published, or republished content exposing plaintiff's residence, surroundings, and personal circumstances. 64. Plaintiff alleges that this publication activity increased plaintiff's risk of further harassment, targeting, and interference with housing stability. 65. Plaintiff further alleges that public officials were placed on notice of this conduct and did not meaningfully intervene despite the risk it posed. 66. Plaintiff alleges that the conduct described above deprived him of liberty-related security interests protected by the 14th Amendment and contributed to continuing danger and instability. 67. To the extent such conduct was carried out jointly with state actors or tolerated by state actors after repeated notice, plaintiff alleges a violation actionable under 42 U.S.C. 1983. Cleggs, 42 U.S.C. 1985-3, conspiracy to interfere with civil rights. 68. Plaintiff incorporates paragraphs 9 through 23 and 31 through 39 as if fully set forth herein. 69. Plaintiff alleges that multiple defendants acted together and in concert with one another to intimidate, isolate, expose, destabilize, and retaliate against plaintiff after plaintiff attempted to seek legal relief and protection. 70. Plaintiff alleges that overt acts in furtherance of this coordinated conduct included repeated confrontations, online targeting, publication of plaintiff's residence, housing interference, administrative gatekeeping, non-response after notice, and retaliatory enforcement tied to October 20th, 2025. 71. Plaintiff alleges that the purpose and effect of this coordinated conduct were to deter plaintiff from continuing to seek protection, punish him for pursuing legal processes, and deprive him of equal access to safety, housing stability, and judicial remedies. 72. Plaintiff alleges that the acts described above were motivated by discriminatory animus, including status-based prejudice and hostility. 73. Plaintiff alleges that as a direct result of this coordinated conduct, he suffered fear, housing instability, reputational harm, emotional distress, and interference with his ability to use the courts and law enforcement systems. 74. Plaintiff therefore alleges a conspiracy to interfere with civil rights, actionable under 42 U.S.C. 1985-3. Reply with continue, and I'll give part 3 of 4. Claim 742 U.S.C. Paragraph 1983, First Amendment, Petition Clause, access to protection, retaliation for seeking court relief and reporting misconduct. 75. Plaintiff incorporates paragraphs 24 through 39 as if fully set forth herein. 76. Plaintiff alleges that he repeatedly sought lawful relief through protection order proceedings, reports to law enforcement, written complaints to public officials, and related judicial processes. 77. Plaintiff alleges that after doing so, he was subjected to intensified confrontations, surveillance, publication, official non-response, and retaliatory enforcement. 78. Plaintiff alleges that the pattern became more severe after plaintiff attempted to use legal process, including the October 20th, 2025 event tied to reissued court papers and attempted service. 79. Plaintiff alleges that the conduct described above would deter a person of ordinary firmness from continuing to seek judicial relief, protection, or official assistance. 80. Plaintiff alleges that defendant's acts therefore violated plaintiff's rights under the First Amendment, including the right to petition for redress of grievances and seek access to the courts, actionable under 42 U.S.C. Paragraph 1983. Claim 8. 42 U.S.C. Paragraph 1983, 14th Amendment due process, court access interference, obstruction of lawful process and burdening of plaintiff's ability to obtain protection. 81. Plaintiff incorporates paragraphs 24 through 35 and 39 as if fully set forth herein. 82. Plaintiff alleges that on October 20th, 2025, he attempted to carry out lawful service of reissued court papers connected to protection order proceedings. 83. Plaintiff alleges that police refused to permit or facilitate that lawful service in a public and neutral setting, despite plaintiff's explanation of his purpose. 84. Plaintiff alleges that this refusal materially interfered with plaintiff's effort to complete process and continue protection order litigation. 85. Plaintiff further alleges that the later harassment charge arising from the same event compounded that interference by punishing plaintiff for conduct tied to legal process. 86. Plaintiff alleges that these acts burdened his access to the courts and to lawful procedures for obtaining protection. 87. Plaintiff alleges that the conduct described above violated plaintiff's rights under the First and 14th Amendments, actionable under 42 U.S.C. Backsheriff 1983. Claim 942 U.S.C. Backsheriff 1983. Monell liability against Larimer County and City of Fort Collins, custom policy practice, failure to train, failure to supervise, or deliberate indifference. 88. Plaintiff incorporates paragraphs 19 through 23 and 31 through 39 as if fully set forth herein. 89. Defendant Larimer County is a municipal entity organized under the laws of the state of Colorado. 90. Defendant City of Fort Collins is a municipal entity organized under the laws of the state of Colorado. 91. Plaintiff alleges that the harms described in this complaint were not caused solely by isolated decisions of individual employees, but were also caused by customs, practices, failures to train, failures to supervise, or deliberate indifference after repeated notice. 92. Plaintiff alleges that Larimer County received repeated notice of plaintiff's reports concerning intimidation, surveillance, online targeting, claimed county affiliation by private actors, and danger to plaintiff's housing stability and safety. 93. Plaintiff alleges that despite repeated notice, Larimer County did not ensure neutral review, meaningful intervention, or corrective action, and allowed the situation to continue. 94. Plaintiff alleges that the county's handling of plaintiff's reports and requests contributed to continued danger and instability. 95. Plaintiff alleges that the City of Fort Collins, through its police department and related personnel, repeatedly failed to respond meaningfully to plaintiff's reports and then participated in retaliatory or obstructive handling of the October 20th, 2025 incident. 96. Plaintiff alleges that the city's conduct was not limited to one officer or one event, but reflected a pattern of non-response, minimization, or dismissive handling of plaintiff's complaints and concerns. 97. Plaintiff alleges that the customs, practices, failures to train, failures to supervise, or deliberate indifference of Larimer County and the City of Fort Collins were moving forces behind the constitutional injuries described in this complaint. 98. Plaintiff therefore alleges municipal liability under Monell and 42 U.S.C. 1983 against Larimer County and the City of Fort Collins. Claim 10, 42 U.S.C. Park 1983. Damages and injuries, 114. As a direct and proximate result of the acts described in this attachment, plaintiff has suffered loss of housing stability, relocation burdens, loss of time, loss of property-related interests, reputational harm, emotional distress, fear for personal safety, humiliation, litigation expense, and other economic and non-economic injuries. 115. Plaintiff further alleges that the conduct described above caused continuing interference with his ability to live safely, maintain housing, seek protection, and use lawful court processes without retaliation or intimidation. Wherefore, plaintiff requests judgment in his favor and against defendants as follows. A. Compensatory damages in an amount to be determined at trial. B. Punitive damages against the individual defendants where permitted by law. C. Declaratory relief stating that the acts described above violated plaintiff's constitutional and statutory rights. D. Injunctive relief as permitted by law. E. Costs, fees were authorized, and such other relief as the court deems just and proper. Parties, capacities, and clarifying allegations. Plaintiff is Rex A. Fredrickson, a resident of Wellington, Colorado. 117. Defendant David Arod is sued in his individual capacity and, to the extent applicable, in his official capacity for actions taken under color of state law. 118. Defendant Chad Gray is sued in his individual capacity and, to the extent applicable, in his official capacity for actions taken under color of state law. 119. Defendant Jeff Swoboda is sued in his individual capacity and, to the extent applicable, in his official capacity for actions taken under color of state law. 120. Defendant John Fine is sued in his individual capacity and, to the extent applicable, in his official capacity for actions taken under color of state law. 121. Defendant Jeanine Hogg is sued in her individual capacity and, to the extent applicable, in her official capacity for actions taken under color of state law. 122. Defendant David Archbell is sued in his individual capacity. To the extent plaintiff proves joint action or conspiracy with state actors, plaintiff seeks relief accordingly. 123. Defendant Robert Thayer is sued in his individual capacity. To the extent plaintiff proves joint action or conspiracy with state actors, plaintiff seeks relief accordingly. 124. Defendant Larimer County is a municipal entity and is sued under 42 U.S.C. 1983 and Monell for its customs, practices, failures to train, failures to supervise, and deliberate indifference as alleged in this complaint. 125. Defendant City of Fort Collins is a municipal entity and is sued under 42 U.S.C. Prac 1983 and Monell for its customs, practices, failures to train, failures to supervise, and deliberate indifference as alleged in this complaint. 126. John Doe officers. John Doe defendants are sued in their individual capacities for actions taken under color of state law. Plaintiff will amend to substitute their true names when identified through disclosure or discovery. 127. Whenever this attachment refers to a defendant acting under color of law, plaintiff means that the defendant used official authority, purported official authority, or acted jointly with a state actor in a manner fairly attributable to the state. 128. Whenever this attachment refers to joint action, conspiracy, or acting in concert, plaintiff means coordinated conduct among public and private actors that, taken together, deprived plaintiff of rights cured by the Constitution and laws of the United States. 129. The claims in this attachment are stated separately to clarify defendant or defendants involved, the factual basis for each claim, and the legal theory asserted. 130. Plaintiff does not allege that every defendant committed every act described in this complaint. Each claim identifies the defendant or defendants to whom that claim is directed. 131. To the extent facts overlap among claims, plaintiff incorporates those facts by reference for efficiency and clarity. 132. Plaintiff alleges that the acts described in this attachment occurred primarily in Larimer County, Colorado, including Fort Collins and Wellington, and that federal question jurisdiction exists because this action asserts claims under 42 U.S.C. Clock 1983 and 1985, 18 U.S.C. Park Break 1962 and 1964, and the United States Constitution. 133. Plaintiff seeks damages, declaratory relief, injunctive relief, costs, and all other relief permitted by law. That completes the full redone attachment in 4 parts.